Hello, everyone. Welcome to Immigration Fridays. I'm your host, Prashanthi Reddy, and I'm here again this week to talk about a new topic, a trending topic that everyone will be interested in. A lot of clients have been asking me about entry of permanent residents. Has anything changed with reference to lawful permanent residents? We've been hearing stories about lawful permanent residents not being allowed back into the country. They've been questioned, they've been harassed. So I've been getting a lot of questions about lawful permanent residents traveling and in what instances they should be careful. So let's dive right into the topic. Like all international travelers, lawful permanent residents, also known as green card holders, are subject to inspection at the US at CBP when arriving at the airport. But generally, we see that lawful permanent residents are not questioned as long as they remained outside the country for less than a year, as long as they have not abandoned their status. Not many questions are asked for lawful permanent residents. And it's very rare that lawful permanent residents are not allowed back into the country or are put into removal proceedings. And we generally see that LPRs enjoy greater rights than non immigrants. And before this, we've never seen LPRs being worried about their status. Let's see what has changed under the present administration. So, under the present administration, we've seen that LPRs or green card holders are being scrutinized at the port of entry more than they used to be. So, let's see what happens at the port of entry. An LPR will be screened at the port of entry either as an arriving alien or as a returning resident. And the officer at the port of entry will decide whether they're going to screen them as a returning resident or an arriving alien. If they're processed as a returning resident, then it's very quick. The processing is very smooth. They ask maybe a few questions. How long have you been out of the country? Which countries have you traveled to? Are you bringing any goods into the country, etc., etc.? And then they, usually allow them back in. However, if CBP decides that that person is an arriving alien instead of a returning resident, then they might scrutinize them further and they might ask more questions. They might decide that they are an arriving alien if the following conditions apply. If they abandoned or gave up their LPR status, if they've been absent from the US for a continuous period of more than 6 months, if they've been engaged in illegal activity after leaving the US, if they have departed the US while they were in removal proceedings. So they were already in trouble, they were in proceedings, and they left, and now they're trying to come back. If they've committed certain criminal offenses in the US, unless, of course, they have been granted an immigrant waiver. So if they've done this in the past, they've had some crimes, but they filed a waiver and the waiver was approved, then they shouldn't be asked any further questions, even if they have a past criminal record. And of course, if they're trying to enter without inspection, if they're trying to cross at the border where there's no inspection point and an officer catches them trying to cross illegally, then of course they can be processed as an arriving alien. So generally what happens if you're processed as an arriving alien? It's possible that, of course, a few questions might be asked, or it's possible that you'll be taken into secondary inspection. At secondary inspection, you will be asked some further questions. It doesn't necessarily mean that you're in trouble, but they may take you into a different room and they may question you for several hours or sometimes longer. And at secondary inspection, the officer will decide whether they want to allow you into the country or they want to put you into proceedings. So a CBP officer may ask questions, they may run checks, collect biometrics, collect biometric data, such as fingerprints or photographs. They might even ask for your phone, your laptop, ask for your password, and search your phone and password for further information. They might look at your social media. So this is something that they do commonly for some non-immigrant cases as well, because nowadays they want to look into your political affiliations, etc. Unfortunately, and your opinions on the present administration. So in some cases, devices will be held. You can ask for a receipt of those devices. Of course, the devices are only held for a temporary period of time. You may be detained if CBP has concerns about your admissibility after looking at your social media or something else in your phone. In this instance, CBP may ask you to sign a Form I-407. So let's talk about what a Form I-407 is and whether you should sign it or not, and what instances they give you a Form I-407. I-407 is abandonment of LPR status. So CBP officer is asking you to volunteer to abandon um, your permanent residence. Please be aware of what this is, and please be aware that if you sign it, then you're giving up your green card voluntarily. So you cannot lose your, please note that you cannot lose your LPR status because of time spent outside the US without being allowed to have an immigration judge review the case and review a presumption of abandonment. So the decision with reference to abandonment, if you've spent more than a year outside the country, cannot be made by the CBP officer. CBP officer can only ask you to sign this form and voluntarily give up your green card status. But with reference to making a decision, only a judge can make such a decision. So you should ask the officer to um, give you a notice to appear so that you can appear before a judge and the judge can make this decision. Please remember, a judge would usually make this decision more favorably than a CBP officer would. So there is an advantage in asking a judge to make this decision, because a decision like this made by a judge will not be made unless there's irrevocable proof that you intended to abandon your residence. Now, so what happens if you refuse to sign a 5407? Then the CBP must issue a notice to appear for immigration court. Now, the CBP might take your green card, in which case then you should ask the CBP officer to stamp your passport. And if they're not able to, or if they don't want to, then you can always take an appointment with USCIS, can ask them to stamp, give a temporary stamp in your passport, which proves that you are a permanent resident. Now, it's possible that you may be detained by a CBP officer. So he can put you in immigration proceedings and he also might detain you. So that's important to know. And it's important to know what your rights are if you're detained. So if a CBP officer believes you are inadmissible, or if you refuse to sign a Form I-407, you may be detained overnight or transferred to an immigration detention center. But you still have the following rights. You have the right to contact your consulate. The consulate can help you contact a lawyer. You may ask to speak with a lawyer. CBP officer may deny access to a lawyer, but it's worth asking for it so that it's in the record. You also have the right to remain silent, not sign any documents without any legal advice, especially if you notice errors on the documents or you did not agree with the content of the document. Please don't sign it. You also have the right to review all written statements that are prepared for you, and it should be in a language that you understand. And if you don't understand it, you have the right to ask for an interpreter. And of course, you have the right to an immigration judge. Let's talk about that further. If CBP claims you're removable, you have the right to a hearing before a judge. Don't waive that right. An immigration judge, not a CBP officer, will decide if you have green card status or if your green card status can be taken away. Please remember that. In addition, you can be asked questions about politics, religion, or activism when you're traveling. A CBP officer may ask about your political beliefs, your associations, your participation in any previous protests. You don't have to answer these questions. You have a protected First Amendment right. You may decline to respond also to inappropriate questions. And we've seen in the recent past, and that's why I've been getting a lot of phone calls where permanent residents were not allowed into the country or were issued removal proceedings and sent into detention because they expressed certain views about the present administration, or they expressed certain views about the healthcare system. There was a scientist that did that and was not allowed into the country. Or we've seen students who are permanent residents who took part in protests who were issued notice to appears and put into removal proceedings. So all this has happened in the recent past. That's why it's important to know that uh, what the environment is right now. Before you travel, some tips before you travel, what you need to do. Consult an immigration attorney before traveling. If you have a previous criminal record, even a minor offense, or even a criminal violation. Previously, traffic violations would never trigger an NTA, but now even minor criminal violations, even if they're traffic violations, are triggering NTAs. Just to give you an example, there was an instance where the person hit another car, another parked car, and there was no one in the car. It was parked in a parking lot. It was not badly damaged, just the bumper. And the person should have, of course, maybe written her number and put it on the car because there was no one there, but she did not know what the rules are. And since there was no one there, she drove away. And then the cops came later on to her house. She was uh, charged with a criminal violation. She had to go to court. She pled guilty, and now she has uh, a judgment against her. So wherever she goes, if she even if applies to jobs, she'll have to disclose that there was a criminal uh, judgment against her. So that's for criminal records. If you have a pending application with USCIS or immigration court, um, then also you should consult an attorney before traveling. If you have past immigration violations or if you've had some challenging interactions with CBP, there's been some finding of fraud, then also I would contact an attorney before you decide to travel. If you're a conditional resident, for example, if you are married to a US citizen and you're now a conditional resident, but maybe you don't meet the terms and conditions of um, that relationship anymore, maybe you're divorced and you've not yet filed for removing of conditions, then you would contact your attorney before you travel. Some other important reminders. Make sure you travel with contact information of your lawyer and your consulate on a separate piece of paper so that you can contact them if CBP ever detains you. Let your family know of your travel plans. Check in with them when you land. If detained, try to contact an attorney. Having a G28 already signed will definitely help the attorney be able to contact you, because otherwise, if they don't have a G28 signed, then they may not be able to contact you. All this is as a precaution only. It's not that if you're a permanent resident, you will have some issue and you will be detained. All this is just to know the worst so that you'll be prepared in all situations. And with that, it's a wrap for Immigration Fridays this week. Immigration laws and processes can be complex and intricate. So if you need any kind of legal advice, please do reach out to us. Prashanthi at reddysq.com. That's my email. I always respond to my email very quickly. Or you can call at my number 212-354-1010. And I'll also give you my extension. It's 1007. Thank you for watching. See you again next week.